Welcome to today's program titled Navigating Political Discussions in California Workplaces. All participants are in listen-only mode. However, you are encouraged to submit questions through the presentation using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be reread and is it required on the CLE credit request form. During the presentation, you will also see a slide containing a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you recently received. Copies of the webinar recording and materials will be distributed to all attendees in the days ahead. On the next slide, you will see the legal disclaimer. This presentation has been prepared by Seyfarth Shaw for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our speakers for today's program, Sharday Skahan and Jonathan Brophy. You may begin.
Great, thanks so much, Madeline. Next slide, please. My name is Jonathan Brophy. I'm the co-office managing partner of Seyfarth Century City, Los Angeles office. My practice is essentially 50% of single plaintiff cases involving discrimination, retaliation, harassment, and the other half of my practice is wage and hour class actions and PAGA actions. And I'm excited to be here today with my partner, Sharday. Sharday, you want to introduce yourself? And I think you're on mute.
Sorry, I muted myself for all my background noise. Hi, everyone. Thank you for joining us today. My name is Sharday Skahan, and I am a partner in the Century City office of Seyfarth as well. My practice is split between single plaintiff litigation and counseling, all different areas for both, including specialized expertise in pay equity, DEI, and workplace discipline. So I'm looking forward to speaking with you all today.
So we have a quick 30 minutes, next slide, and we've got a very high-level agenda for you folks. 2 weeks from today is Election Day, November 4th. We know that based on the questions that we're getting from our clients, there's a lot more interaction with employees regarding the current events of the day, whether it's No Kings rallies this past weekend or MAGA rallies coming up, or just general items in the news. We wanted to run through the basic lay of the land here in California so that you as an employer have the wherewithal and the tools to address those particular situations that might come up. And then we'll run through the FEHA and Title VII considerations and practical approaches. Next slide, please. So for state law considerations, next slide. It's important to remember that the First Amendment applies to government action. There's no constitutional right to free speech in a private workplace. And broadly speaking, just to set the stage, if you're in another jurisdiction, over 40 states have laws to the effect of prohibiting employers from stopping employees in engaging in any sort of political activity or advocating for any sort of political party or political movement. And of course, that varies state by state, but we're here to discuss California specifically. So next slide. There are 4 basic statutes that employers need to be aware of that provide employees protection for lawful off-duty conduct. The first labor code section is 96K, and that is a broadly worded provision that really deals with the labor commissioner being able to take assignment of claims for wages due to an employee being demoted or terminated or suspended because they engaged in lawful conduct occurring during non-working hours. The mechanism of enforcement is found at Labor Code 98.6A, which we have set forth here. And it essentially prohibits employers from any sort of discrimination, retaliation, or adverse action against an employee who has engaged in conduct set forth in Labor Code Section 96K, which again is lawful conduct occurring during non-working hours. The second, next slide, the third and fourth provisions that we want you all to be aware of in case it isn't already on your radar is the Labor Code in California prohibits employers under Section 1101 from having any sort of rule or policy that forbids or prevents employees from engaging and participating in politics or from becoming candidates in public office. And then Labor Code 1102 essentially states that no employer can coerce or influence an employee to take a particular political position or otherwise act against them. So a lot of times our clients, when they're calling, are not aware of these, and they're thinking of these just generally speaking in the context of their anti-discrimination or anti-harassment policies, which Sade is going to touch on in a moment. But next slide. The important point to note here is whether or not an employee is engaging in off-duty conduct. And there's a recent case that just was decided about 2 weeks ago in the Northern District of California, Coritum versus Microchip. And in that case, the court denied summary judgment for the employer. The facts are just high level. The employee posted on social media multiple times on the morning of October 7th, 2023, about the Hamas attacks in Israel, and then sent an email to the CEO, who had sent a firm-wide email about the attacks, thanking the CEO for acknowledging suffering on both sides. But within 5 days, on October 12th, that employee was terminated from their employment. And the employer essentially argued that lawful off-duty conduct did not apply here, and Section 98.6 wasn't at play because he was a manager and he was held to a higher standard. And the court didn't buy that. The court also rejected the employer's arguments that the actions it took in that 5 days did not raised tribal issues of fact, precluding summary judgment. So it's worth noting that a situation that happened in the heat of the moment during those charged times 2 years ago is still ongoing and is still playing out 2 years later. And part of what happened in that situation was the employees who had access to the individual posting, they saw their social media posts and reported it to the employer. That's where we're seeing a lot of these complaints arise. And so when we get into Sade's section, we're going to talk about how to apply the facts that you've received from your employee or outside customer or just general member of the public about their concerns related to another employee's postings. One thing that we wanted to mention is that the NLRA is also at play here. We could spend a ton of time talking about that as well. But essentially, you should also have in the back of your mind as you field any sort of questions or concerns from your employee workforce, whether or not the NLRA is implicated. And that protects certain concerted activities for mutual aid or protection. And so there's a whole host of cases and case law in the NLRA context dealing with individuals clicking like on a Facebook post or sharing a Facebook post or sharing other social media information. So when you are confronted with these situations, even if it is a heated situation and there's a lot of attention on it, it's important to partner with your business units internally to understand how you're going to approach a situation and investigate what's going on. Next slide. Here in California, it's also worth noting that the legislature passed a law that went into effect January 1, 2025. It's basically California's version of the captive audience laws that basically prohibits employers from requiring employees to attend meetings that express the employer's views on political or religious matters. The statute said that attendance has to be voluntary. Employers are still allowed to hold those types of meetings, but you cannot force employees to attend. And in retaliation, employers are prohibited from retaliating against employees who refuse to attend. And then we've got the enforcement up here. This law was enjoined from going into force in September of 2025. The court found that the law, SB 399, acted as a viewpoint and content-based regulation that couldn't withstand strict scrutiny under the Constitution. So it again is important to note that there are tools that are available to employers, but you have to be treading very carefully. And one thing to note for Labor Code 98.6, an employee who's been terminated and who brings such a claim and is successful in proving that an employer violated 98.6 is entitled to reinstatement and reimbursement. And indeed, if that individual employee is terminated within 90 days of engaging in that lawful off-duty conduct, there is a rebuttable presumption in favor of the employee that the employer did in fact violate Labor Code Section 98.6. So with that, I'd like to go to next slide and throw it over to my partner, Sharday.
So now we'll talk a little bit about some of the other considerations, including Title VII and FEHA, and some more practical aspects about how you can make sure that you're reacting appropriately if you were to receive a complaint or became aware that an employee were engaging in some sort of off-duty conduct that you had concerns about. Next slide, please. We kind of view it as a spectrum when you're evaluating whether or not there's an impact on the workplace for political expression that one of your employees may be engaging in. All of these things should be considered when evaluating how you want to respond and how you need to respond. So a lot of times we see employers get into trouble because they react too quickly when they become aware of a situation. And it really does take a thoughtful approach to make sure that you don't walk into other issues. So maybe you might have issues arise from whatever conduct this employee engaged in, but if you respond too quickly without really evaluating the situation properly, then you can get other complaints or lawsuits from the employee, kind of like the case that John just discussed. So the first thing that we look at is what kind of effect does the conduct have on coworkers? Is there actually an effect on the coworkers at all? Maybe you became aware of a situation that occurred, but it doesn't seem to have any sort of impact actually on the workplace, even if you don't necessarily like it. So we need to evaluate whether or not it's affecting the coworkers and people with whom this individual works. We also want to look at whether or not it's giving rise to any complaints. As I mentioned, sometimes there aren't complaints that arise from a situation, but maybe an employer is made aware of something. And then sometimes an employer is actually receiving complaints from either members of the public or other employees or individuals who become aware of this employee's conduct. Right now, especially in the social media age, there's a lot of doxing that occurs, that someone engages in conduct publicly and then people find out where that person works, or they look at their LinkedIn and then they report to the employer that this individual is engaging in this conduct, and what are you going to do about it? So complaints aren't necessarily just going to come from the coworkers or employees. We also want to evaluate whether there's any sort of effect on job duties. Is there any sort of connection to this employee's job, the conduct that they're engaging in? And then is there damage to the company's reputation, and to what extent is there potential damage to the company's reputation? Sometimes the damage looks like it's going to be worse than it is. Sometimes there's damage that's going to occur because of the particular industry that the business is engaged in. So we want to evaluate whether or not this conduct that the employee engaged in is going to have any potential reputational damage. And then are we going to need to take action to kind of stop the bleeding if that's going to occur? And if so, what type of actions would be appropriate and warranted by the situation? And then finally, we're going to evaluate whether or not there's actually an effect on any customers, investors, applicants, basically any third party that would be connected to the business that might be impacted by this individual's conduct. So you're looking at it from a multifaceted angle. You're looking at what effect you have on coworkers, what internal effect are we having, but also what external effect are we having with the reputation, and then any third parties that might be connected. And then next slide. And then you want to also consider whether or not this political expression is going to implicate a protected classification. Frequently now, a political expression is going to tie in some way to some sort of protected classification. And before, it was kind of you leave your personal self at home and then don't bring all of that stuff to work. But nowadays, increasingly, we see in the workforce that people are kind of bringing their whole selves to work, for better or for worse. So that means that whatever they're engaging in externally might be some kind of political expression, oftentimes is tied to some kind of protected classification that this individual holds. And then when they bring that back to the workplace, that causes a lot of complicated factors. So if you're evaluating the political expression, you also do need to evaluate if it is tied to a protected class and in what way. Because throughout all of this, you want to make sure that you are being careful of Title VII, the California Fair Employment and Housing Act, and then any other state laws that might apply to potential anti-discrimination, anti-retaliation, or anti-harassment. Next slide, please. When you are evaluating whether or not the political expression is going to violate a company policy, there's a lot of potential policies that apply. This is a sample, but as you're all aware, not everyone has the same type of handbooks or policies in place. So you have to evaluate for your business whether or not this political expression violates or potentially violates any policies that you have in place. These are the most common policies that are often implicated. They might have different names, especially for the diversity inclusion policy. A lot of employers aren't really using that term for those types of policies anymore, but you're considering the content of the policy and what is being prohibited and what is supposed to be protected. Generally, company policy doesn't really govern the off-duty activities of non-management employees, but as we've discussed throughout this presentation, sometimes it's going to. So you need to evaluate whether or not any conduct that you became aware of is actually potentially in violation of company policies. Other things that you want to be particularly cautious of if you become aware is, were there any threats of violence involved? Were there any protected classifications implemented or mentioned in this conduct? Is it adversely affecting the work environment? Those are things that you need to pay particular attention to and be very cautious if you become aware of any of those instances. Policies should be clear that they apply to employees, even if they're not physically at work. This is particularly important in the hybrid and remote work environments that we have nowadays, because not everyone is at a brick and mortar office. So the policies have to be clear that they're going to apply to these employees, whether or not they're actually physically at the workplace. And then social media policies can similarly set very clear boundaries of what is permissible, what isn't permissible. Are you representing the company when you're on social media? Are you wearing some kind of company logo or something on your shirt when you're out engaging in these activities, such that someone might interpret you as, or interpret the employee as speaking on behalf of the company or acting as a representative of the company when they're engaging in this type of political expression. And then John mentioned too the NLRA and how that might apply. So those are things that you want to consider as well when an employee is engaging in this type of conduct. Do we have any particular issues that are going to arise under the NLRA? Is it going to be considered protected concerted activity or not? Next slide, please. So practically speaking, kind of what are the other things that we can do if we receive some kind of complaint or there's an issue that arises? How do we handle it? And in very lawyerly fashion, of course, it depends. There's no bright line rule about how to handle these situations, and there's no clear-cut answers either. There is a lot of discretion that is involved in these kinds of considerations, because it really does depend on the situation at hand. It depends on the workforce. It depends on how serious the conduct was that occurred. So there's no way for us to say this is what you always do in this circumstance, which is why it's really important for those who would be involved in discipline or evaluating the situation to have a clear understanding of kind of the framework that you're going to operate within and what to do if you receive some kind of complaint or concern that's been raised. So of course, the company culture is going to matter. Different industries have very different cultures. Different businesses have very different cultures. Part of it too, we're seeing a lot depends on the age of your workforce. If you have a more traditional workforce versus a much younger workforce, the company cultures vary greatly, and that can affect kind of how you're going to respond to these types of situations. A lot of times now too, we see employees, especially in the younger workforces, kind of ask for a lot from their employers, and they want to hear a response on something or know how the employer is going to take action. So a lot of that is being demanded by the workforce, which sometimes is driving the response of the business, again, for better or for worse. And then we want to look at how much political expression can or do we want to police. It's a very, very gray area when you're policing this type of expression, this type of speech, and you want to evaluate how much do we want to be in this, or is it going to become a distraction to our workforce if we are policing this too much, in our view. And then how do we stay somewhat and reasonably consistent with our actions? This is critical when evaluating really any type of discipline, but especially when it comes to things like off-duty conduct or political expression, because this is a lot of the times how we see the complaints develop, that there's not consistency in how these situations are treated. And then it gives the appearance of either preferential treatment or unfair treatment, which leads to separate complaints. So then you're dealing with a complaint about the conduct itself, but then also a complaint from the individual that they're being targeted and treated unfairly because of how the company is handling these situations.
I like to think of it as, very similar to a harassment investigation. When an employer is faced with a fact pattern, one of the questions that we got, yes, slides will be made available. And another question was, how do you draw the line between something that's political when everything feels political, even when talking about human rights? I think it comes back to that sort of notion of, you do need to just look at exactly what is happening on the ground, what was said and by whom and in what context. That's a lot of what the folks on this call deal with when they're faced with a complaint of harassment or discrimination or retaliation, which I think goes to a nice segue for the next slide. Charday, you want to talk about that?
Yeah, exactly. Because you're still evaluating your policies at the end of the day. And so just like if you received any other complaint of discrimination, harassment, any type of workplace misconduct, you're going to investigate it. So same situation here, which is why, again, we said it's really important to not just react without thinking through your actions. And so you need to conduct some sort of investigation into the conduct that occurred in the complaint that was received. And as John mentioned earlier, these situations can move very quickly. So it's not necessarily going to have to be an investigation that's going to take months, but you do need to conduct some kind of investigation before you react too hastily. So you're going to engage in fact gathering. You're not going to make assumptions. Again, you're not trying to tone or content police. We are really evaluating how this is related to our policies, and is this going to violate our policies? You want to interview those who were involved, the complainant, of course. You want to interview the individual that was accused and try to be as thorough as possible. Even though these investigations do need to move quickly, you still need to be thorough in your investigation. And then, of course, no retaliation.
Yeah, and I was going to also add to Charday's point there. One thing we see a lot in cases is when somebody makes a complaint on the way out the door and they leave, and an employer says, well, they're on their way out, I don't really need to investigate. In California, you need to investigate. And it's better practice for you to close that loop, interview the folks that you need to. And even if the complainer does not want to participate any further, our advice is always close the loop, document it, investigate, and then that way you're protected later on if and when that employee sues, or if and when you're faced with a similar situation, because then you can point to those protective measures that you put in place in any potential later litigation. So investigate even if the employee leaves the company.
Yeah, and if the employee doesn't want to participate, you should still document that you made an effort to reach out and interview that employee or former employee, so you have that record as well. So later they can't say that no one tried to talk to them about it. Okay, next slide, please. So if the complaint is substantiated, then the employer needs to evaluate whether or not they're going to take action on the conduct, and if so, what's appropriate. Again, we want to stress that you want to be as consistent as possible when you're handling these situations and when you're handling violation of company policy. So even though sometimes some of these situations can be very inflammatory, you still need to always think back to, is this a violation of company policy? If so, how severe is this violation? And then how should we handle this? These are just some examples of the types of discipline that can be applied. Again, it's on a case-by-case basis, so no bright line rule here. Next slide, please. We always recommend, especially nowadays, to invest in training on these various subjects. This helps employers know how to be more proactive when these situations arise. And it's really important that the in-house legal team is educated on the framework that applies, but also that the HR team or people ops knows what they should be doing and knows what the boundaries are when one of these complaints come in. These in the past haven't been as common types of complaints. So sometimes HR is a little bit nervous or unclear about how they should be handling it. But HR should have received training to understand that if we receive a complaint like this, you're treating it like everything else. You need to look into it and investigate and figure out whether or not any sort of discipline is going to be warranted. Okay. Next slide, please. Yeah. So, of course, we're here if you need any help on any of these issues. They're often very thorny, very complicated, and heightened emotions are involved, which makes them very tricky to manage both internally and externally. But you can use the three-pronged approach. Make sure that your training is on point and that your policies are up to date. And then you want to look at kind of the voice of the client, which means what is going to be true to your organization and what is going to make sense for your workforce. And then we try to make sure that we're applying that as well when we're evaluating these circumstances for you and partnering with you. And then finally we have a team that kind of deals with this stuff all the time that we call the cultural flashpoints team, that deals with these types of hot button issues that arise in the workplace. And that team is always ready and willing to be able to help on any of these issues should you need any or want any hypotheticals or just kind of walking through some best practices of how you should respond to these issues should they arise. Okay. And then
I think,
oh, go ahead.
Go ahead, Sade. I was going to say, I think we had a couple questions. We might have time to answer a few of
Sure.
these. So one of the questions was, what was the name of the case? That was Coritem versus Microchip Technology, Inc. And Coritem is spelled K-O-R-A-I-T-E-M. The Westlaw site is 2025 Westlaw 285-6292. And that's the Northern District of California. Judge Davila from October 8th, 2025. And again, the site is 2025 Westlaw 285-6292. Then we got a question about Labor Code 1101. Is it possible for an employer to designate certain positions as incompatible with participating in politics? For an example, an employee whose job is community relations that require positive relationships with people from different political parties. I would say here you would want to focus on the job description itself rather than a blanket policy or description. If the job description itself and sets forth and enumerates that the essential functions of the job are engaging with different political parties, I think that job description would do the work rather than a blanket prohibition on 1101 and prohibiting employees from any sort of politics. I think that sort of policy would run afoul. We did get a couple questions if the slide decks would be available, and the answer is yes, they'll be sent out. Let's see.
I see a question about whether there's an obligation to let the employees know of the outcome of the investigation. There isn't. Usually you'd want to send some kind of closure letter letting the individual know that the investigation has been completed, but you don't have to advise them on what type of discipline is taking place, if any.
And I think that is all for our time. We want to read the CLE code for folks, and we'll close out any remaining questions that we didn't get to. Madeline, if you want to take it away with the CLE code, we thank you all for your time and wish you the best of luck in this upcoming election season.
And then for the code, we have SS0119. So SS as in Seyfarth Shaw 0119.